Welcome to the world of ADR, where we discuss alternative dispute resolution practices in various jurisdictions. Today, I'm privileged to have Marcus Gomes from the Felsberg firm in Sao Paulo, Brazil. Marcus, welcome, and thank you for being here today.
Thank you.
As we begin, let's get a little background. Tell me a little bit about your firm and then a little bit about you and your practice.
Okay, sure. Well, first of all, thank you very much for the invitation. It's a very interesting project. Well, my firm is Felsberg Advogados. It's a Brazilian full law service firm. We have offices in São Paulo, Rio, in Brasilia, and as just it happens with any full service law firms, I think that we cover the usual and most important areas of law, but in most of the cases dealing with corporate clients. I personally deal with dispute resolution, meaning that I both do litigation and arbitration, domestic, sometimes international, acting as counsel, and sometimes even as an expert witness.
What types of arbitration does a firm like Felsberg normally see in Brazil?
Well, there are a variety of cases, but I would say that most usually we deal with corporate law, M&A transactions, construction, infrastructure, and energy. Sometimes insolvency as well. But when we talk about insolvency matters, there's some very interesting, because some things that can go to the jurisdictional arbitration and some others stay with the regular courts, depending on the nature of the dispute.
By the way, I would be remiss if I didn't comment, and you may or may not know this, but I had an issue that needed to be dealt with in Brazil, in Brasilia actually, and your firm was wonderful to deal with and incredibly helpful and made the issue much easier for me. So I just wanted you to know that I personally appreciate that. So thank you on my behalf. So the ICC reports that Brazil has the 5th most arbitrations in the world. What has caused arbitration to become such a popular method of dispute resolution in the country?
Well, our Arbitration Act dates 1997, and for some years there are some discussions in our courts regarding its constitutionality. But it has been finally solved in 2001, and since then, indeed, arbitration developed a lot in Brazil, and now it's a very, very consolidated practice. I would say that there are essentially 3 reasons for this. The first one, let's say, would be that a matter of speed, because our regular courts tended to be somehow slow, especially because Brazil is a root country, and these cases usually go to the state courts, and the state courts, depending on the part of the country, differ substantially. So arbitration is showing to be faster, generally speaking, than courts. And also because in most of the cases, well, in almost all the cases, the arbitral award is final and there's no possibility of any kind of appeal against it. So speed, I think, is the first aspect, in spite of the fact that arbitration is not today as fast as it used to be some years ago, possibly because the practice is very developed, but I think that we need some new arbitrators, possibly, because they are dealing with the same case all the time, and so things are not so fast as it used to be. In addition,
so wait a minute. You think part of the slowdown is that everybody's trying to use the same arbitrators, and that slows down because they're too busy?
Yeah, I think so. Not necessarily because, well, in a certain way, yes, because they use the same arbitrators, but We need new arbitrators, younger arbitrators, but this is happening, this is happening, but I don't think it's still in the proportion of the practice of arbitration in Brazil. So as soon as we have more qualified arbitrators, and we have very good ones, I think that the speed is going to be balanced, to improve in terms of arbitration.
So who generally then are the arbitrators? Are they lawyers, judges, business people? How is that done in Brazil?
Well, under our law, any person that is considered to be legally capable and is elected by the parts because the parts trust in this person can be an arbitrator. But in most of the cases, arbitrators are reputable, experienced lawyers in arbitration or even in the subject matter of the dispute. Although I've seen during the years cases in which one of the members of the tribunal was not a lawyer, could be an accountant, an engineer, depending on the issues under discussion. But in most of the cases, we are talking about lawyers.
So have you found yourself maybe talking to lawyers who are, young partners, senior associates, if that's how it's done in Brazil, and suggested that economically and business-wise, it may be a good idea to consider becoming an arbitrator? Is that something that is part of people's conversation at law firms now?
Yeah, I think so. What happens is that when you are in a big law firm, it's very difficult to be consistently an arbitrator because of conflicts, and it's not unusual that the lawyers that are very specialized on it and want to be solely arbitrators leave the big law firms and open small law firms, boutiques, in order to render services as arbitrators solely.
Yeah, it seems to be a wise business decision if they're in need of arbitrators in the country. That makes sense.
Certainly. And the issue of conflicts is very sensitive these days because as these arbitrators are dealing with several cases at the same time and sometimes related to other firms, this is something that really should be considered very carefully. And under a law, it is one of the few circumstances that can make a court of law to declare an arbitration award to be null and void. So it has to be dealt very carefully during arbitration.
So let's talk a little bit about, you said under the law, and you talked about earlier the Arbitration Act in the country. So generally, if I understand correctly from you in our earlier discussions, the Arbitration Act is based upon UNCITRAL, the UN forms and policies. So arbitration in Brazil is very similar to arbitration in many of the other common law or civil law, I know you're a civil law country, in the civil law countries that have adopted the UN rules. Is that fair to say?
That's true. The principles are essentially the same. The law reproduces most of these principles. So dealing with arbitration in Brazil, of course, the way lawyers think sometimes is a bit different. But in terms of how the proceeding works, dealing with arbitration in Brazil is likely not so different as dealing in New York or in Houston or in Paris,
So, and Brazil is party to the New York Convention. So under your act, you will recognize, if you follow certain procedures, a foreign arbitration, just like it was domestic, right?
Right. Both domestic and international arbitration awards are perfectly enforceable in Brazil. The only thing to be considered is that as it happens to foreign judgments, the international arbitration award to be enforced in Brazil, this is a constitutional problem, must be first confirmed by the Superior Court of Justice. And the Superior Court of Justice is not going to re-examine the evidence, the grounds, the decision itself, but just to check some formal aspects, if there was a valid arbitration agreement, if the parties were able to take part in proceedings and to defend themselves because they were properly served. If the arbitration, if the decision is in accordance to the agreement that has been entered into by the parties, and if the decision, the award is against public policy, what is generally very, very unusual when we're talking about commercial disputes.
And are those the same grounds that a party to a domestic arbitration could reach out to the court and ask for an appeal, or are they different grounds?
In part they are, but there are some other aspects when we deal with the domestic award, because what happens is that the domestic awards do not have to be confirmed to be enforced. They are immediately enforced. But in some circumstances provided by law, it's possible to go to the regular courts of law to try to obtain a decision, a judgment, to declare this award null and void. Basically, it happens when the award has not been rendered in accordance with the limits of the arbitration agreement. The subject matter is not the one agreed by the parties, I mean. When the time frame for rendering the decision is not respected by the tribunal, when the requirements for the arbitration award were not observed, there are some formal requirements, but very logical ones. This kind of discussion does not exist at all. For instance, the arbitration award has to be the discretion of the matters in discussion, the reasoning for the decision, the reliefs that are granted, the signatory of the arbitrators, the place in which to render. Well, all of this, generally speaking, is compliant, you know? And I think that the most sensitive aspects are that the arbitration award must be rendered by someone that's qualified to be arbitrator, meaning that he's impartial, meaning that he has not been forced to render a decision against his understandings, his position, his conclusions. And the award must deal with something that is considered to be arbitrable under Brazilian law, because there are few subjects that cannot go to arbitration in Brazil. And of course, when I say that the arbitrator must be impartial, it means that there is no, and that's the problem of the duty of disclosure during the proceedings, because at any time in which there is any kind of reason, issue, matter, subject that may represent some kind of uncertainty about his impartiality, he has to disclose this to the parties.
So you just said that there are some things that cannot be arbitrated in Brazil. What type of disputes would that be?
Yeah, in general, what our law says is that the so-called waivable, what we call in Brazil of waivable rights, can go to arbitration. What are waivable rights in accordance to our law? Any economic right in relation to it, individuals or entities are free to dispose. What covers most of the thinkable commercial disputes. But there are certain things that represent public policy that cannot go to arbitration. Essentially, things like criminal law, family law, and things of this nature. And there are certain other areas of law in which arbitration is admitted, but with certain restrictions. That's what happens in relation to labor law matters. that can go to arbitration, but with certain restrictions. For instance, it depends on individual labor claims or disputes can be arbitrated depending on the amounts that are paid to employee. Up to a certain level, he can go to arbitration. Below that, he cannot. And that's very, very interesting. Also, if the employee has a bachelor's degree, because it depends on his ability to decide freely to go to arbitration in accordance to our law. If these requirements are not met, the arbitration agreement cannot be imposed to him. He can go voluntarily, but if the opposing party commences arbitration, he can oppose to it. Okay. And in consumer law, also there are some restrictions in relation to arbitration. Well, the arbitration agreement must be a very specific agreement, separated from the general adhesion contract, and in adhesion contracts, similar to what happens in most of the cases of the individual labor claims or disputes, the arbitration cannot be imposed on the consumer, but he can freely, voluntarily goes to arbitration if he wants to. Okay, so this makes arbitration in these areas less usual.
So those limitations that you just spent a minute or two discussing, if you have an international arbitration that involves those issues, do those limitations still apply, or does that only apply to arbitrations in Brazil?
I think so, because this would be a matter of public policy.
Okay. So when you go to the court to confirm an international arbitration, one of the things they will look at is whether the underlying dispute was within the public policy of Brazil allowing it to be arbitrated.
Yeah.
Interesting.
But personally, I've never seen a case in which this kind of arbitration award has been confirmed by the Superior Court of Justice, because these cases are really not so common, I would say.
Well, I understand that Brazil's one of the countries that you cannot arbitrate investment disputes involving the country.
Yeah.
Right?
The real issue is not that we cannot arbitrate. The problem is that the Brazilian Brazilian state is not party to any of the usual BITs. This makes the investment state arbitration virtually inexistent in Brazil. Okay, what happens is that when you have arbitration involving state entities, state-owned companies, this usually is commercial arbitration in Brazil. And this is possible, at least from 2015, because the law has changed to make it possible for the state to be involved in commercial arbitration with some few restrictions. The restrictions are: arbitration involving the state must be public, so confidentiality does not apply here, as it applies, generally speaking, to commercial arbitration. And the decision, the award, must be solely grounded in legal grounds, meaning that it cannot be an equitable decision and as equo et bono decision, as it may happen in commercial arbitration if there is a specific provision allowing the arbitrator to decide by equitable reasons.
And do commercial entities ever have a provision like that?
Actually, yes. I've saw it. and very recently inclusive. But the funny thing is that it was a case with a sole arbitrator. It was an ICDR arbitration, but the place of arbitration was Brazil. The seat of arbitration was Brazil. And the arbitrator did not think that it would be necessary at all to decide by ex equit bono basis, because he found in the law the solution to the case. But he was allowed to, if necessary. If he concluded the law was not, the strict law rules were not fair under that circumstances, he would be able to make deviations of it.
Have you ever been in a situation where you have advised a commercial client to add a provision for equity, which in my mind means you don't really know what you should or shouldn't do under the contract? And second, you don't have any certainty to evaluate a potential arbitration because the arbitrator can do what he or she thinks is appropriate.
I entirely agree. I've never advised my client to put this kind of disposition in the agreement, but it may happen.
It's an interesting exception. It's curious. We spoke before going on camera on how arbitrations, the agreement to arbitrate generally has to be in writing in the underlying contract in order for arbitrations to be valid. Explain to me, because what can happen here is you may not have an arbitration agreement, but once you get into a disagreement with another commercial party, you can all agree to arbitrate. Yes. Is that something you could do even if it's not in your original contract in Brazil?
Yes. Okay. Yes. What the law says is that the agreement to arbitrate a dispute must be written. But this agreement may be in the existing contract between the parties, there's an arbitration provision in the contract, or it may happen later when the dispute already exists and the parties decide to arbitrate, and they may enter into agreement for this purpose. So both situations are possible, but from my experience, it is really more usual to have it provided in the contract already. Yeah.
So we talked a little bit about the types of things that are arbitrated in Brazil. I understand from you that corporations can actually put arbitration agreements into their bylaws that require shareholders which have disputes to arbitrate with them. Is that true?
That's true.
Because our Securities and Exchange Commission is changing the rules here to allow that to happen, but before it is not something that you could do previously, and it is now changing apparently to get closer to the Brazilian model.
Yeah, a few years ago, there were lots of discussions in Brazil about this issue. This was a raw topic, but the law has been changed also to make it clear. When you are talking about corporations that have the shares negotiated in the market, you can perfectly have a provision like that in the bylaws, because when you buy shares, you know this, and you have to comply with this regulation. And even if this provision is changed later, you are always free to sell your shares in the market. The problem is when we're talking about closely held companies, because in this case, it might be a bit different, because if you are a minority shareholder and not happy with the arbitration provision to be put in the bylaws, it's going to be more difficult because you cannot simply go and sell your shares in the market. What the law says that in this case, if there is a change in the bylaws to incorporate an arbitration, you are free to leave the company within a certain frame of time after this incorporation in the bylaws, this change in the bylaws. Okay.
So in other words, if you buy into the closely held corporation when there already is an arbitration provision, then you have to abide by the arbitration provision.
Perfect.
It's only if there's a change. Interesting. That's interesting. So we said earlier that Brazil is obviously a civil law country, as opposed to US, which is common law country. How does that difference, if at all, impact the way an arbitration is conducted?
Well, I'm not so sure it changes at all today, because arbitration is, let's say, an international phenomenon. And when we talk to other lawyers from other jurisdictions and go to events in any part of the world, well, the essential principles are very similar. And what we see in the last years in Brazil is that several practices that were very strong in international arbitration are now being incorporated by lawyers and arbitrators in domestic arbitration, making the difference less significant.
You said incorporated. Is that incorporated into an arbitration agreement, or is it incorporated into the rules of the entity you are using to do the arbitration under?
A bit of both. Okay. You can see this in some rules of arbitration institutions, and you can see this in the terms of reference the parties agree when they commence the arbitration.
So the terms of reference wouldn't necessarily be in your arbitration agreement. They would be something you specifically agree to as the way you're going to conduct the arbitration once you have an arbitration panel chosen.
Precisely, yes.
Okay, and talk to me a little bit. I'm sorry I interrupted you. Talk to me a little bit about what types of things from international arbitration are generally being adopted in Brazilian arbitrations.
For instance, the production of evidence. In Brazil, some kinds of disclosure that we see in common law countries was not common, okay, especially at the courts. But in arbitration, they are really very, very strong practice now. And another practice related to this that's very strong today in arbitration in Brazil is the use of witness statements. That was something that we are not used to do, and at the court it does not exist at all. And the red fair schedules in order to organize the production of evidence. A practice that's very strong today as well is to use a certain soft law principles as guidance for production of evidence, as it happens with the IBA rules on production of evidence. It's very usual to have reference to them in the terms of reference as a guidance for production of evidence. So what I can say is that domestic arbitration in Brazil is today possibly very similar to international arbitration.
So let me backtrack a second. Just looking at something like the IBA rules on the production of evidence, does that generally allow for broader discovery than you would get in a court of law in Brazil?
Yes.
Okay. So you are turning a little more toward the common law model. Interestingly, in domestic arbitrations in the United States, I think we're very similar to Brazil in that we don't have a tradition of using witness statements. That is certainly what common law countries do based on England and Singapore and things like that. We generally don't do that. We have what you had before you started accepting them, which is you have to present witnesses at the hearing. Arbitrators can ask them questions, not that you just do cross-examination of witnesses. So it seems like we may be one of the last bastions of domestic arbitrations that don't use witness statements that often. So I think that is an interesting distinction.
Yeah, it has advantages and problems as well, you know. In a certain way, it makes things easier to the, from my perspective, to the tribunal, because the tribunal can make it clear what are the subjects, or at least what are the range of subjects that are going to be discussed in the hearing, when the witnesses are going to be questioned and cross-examined. But
what authorities do arbitrators have in Brazilian arbitrations to control discovery? Can they sanction people for failure? Can they get discovery from third parties? And if so, how do you do that in Brazil?
Yeah, the arbitrators have have powers, but they are restricted, because that's very interesting question. Our law says that the arbitrator has the same basic status of a judge of law. Okay, but the problem is that he has not the ability of the judges to enforce decisions. So what happens is that when the arbitrator issues a decision and it's not voluntarily complied by the parties, as it happens when he decides to hear a certain witness, and the witness does not cooperate and does not go to the hearing, he can ask assistance to the judge, to a judge of law. Okay, it's what we call of carta arbitral. That's let's say, well, I do not say it's a good example, but it's just like let's say a letter rogatory. It is a request the arbitrator addresses to a judge of law, and the judge of law, using the powers he has, orders the witness to go to the hearing.
And does that only apply to forcing a witness to a hearing, or can it also apply to getting documents?
Yes, to anything that you can imagine, okay? The most usual things are related to the conduction of witnesses to the hearing, and eventually to the production of other kinds of evidence. But the law is open, you know. In theory, any enforceable powers that the arbitrator or the tribunal has not, the tribunal, the arbitrator may request to a judge.
So those rules are very similar to what we do here, though arbitrators have the authority to issue subpoenas that are enforceable in court. So very similar. Are there particular tribunals that are often used in Brazil? And if so, what are the different ones? Any differences between them? Is it location based? Or how do people decide what tribunal to use?
Well, I think that we now have a good range of arbitration tribunals or institutions in Brazil that provide reliable services. It, of course, depends on, let's say, the size of your dispute, because some of them are more expensive, some of them are more expensive than others, and it depends on your case. But I would say that the most common ones in most of the commercial disputes are the Kansas CBC, the arbitration chamber of the Brazil-Canada commercial chamber. The ICC in Brazil, the ICC has offices in Brazil. It's not exactly Brazilian, but let's say that it's domesticated because the ICC has offices in Brazil. Okay.
So you can do a Brazilian-based arbitration through the ICC tribunal in Brazil.
Yes, yes. Okay. The São Paulo Chamber of Reconciliation and Mediation and Arbitration of the CIESP, FIESP, that is an association of industries of the state of São Paulo. The FGV Mediation Arbitration Chamber, that is an arbitration chamber related to a law college that's very reputable, very usual, very common in energy disputes. The AmCham Center of Arbitration and Mediation, that's the arbitration institution of the American Chamber of Commerce in Brazil. And possibly, it's a very specific area, but the Market Chamber, that's the São Paulo Stock Exchange Mediation Arbitration Chamber.
So taking the last one out, because that sounds like it would be for a very specific type of dispute. When you are negotiating a contract for a client with an arbitration provision, how do you decide among all the different options what you are going to suggest to the client to include as the tribunal? Well,
among Brazilian companies or individuals, Kansas CBC, AmCham, FGV or CIESP, FIESP arbitration chamber are very common. Okay, sometimes when we're dealing with international parties, possibly they will be more confident about ICC.
Okay, but there, in your mind, if it's a inter-Brazilian contract, any of them are as good as the others?
I think that all of them can render very, very reliable services. Really.
Interesting.
And that's something very important, because as I mentioned, you can have in Brazil basically the same arbitration you can have in any other part of the world, even with international institutions, as it happens with ICC, as it happens to ICDR. As I mentioned, I had the case Brazilian arbitration organized by ICDR last year. The advantage of this, however, is that you avoid the need of confirming the decision, the award, before enforcing it in Brazil. So if you have the seat of arbitration in Brazil, you do not have to pass through the confirmation proceeding to enforce the decision.
How long does that confirmation proceeding normally take?
It should be straightforward, and generally it is, but I would say that on average 6 months, if there is no opposition, no impugnation, but it may be 1 year or even more if there is any kind of dispute.
If there's a dispute at the front end of a dispute, where one of the parties says that the arbitrators do not have jurisdiction over the specific claim, does Brazilian law allow the arbitrators to decide their own jurisdiction?
Yes.
Or do you have to go to court? Okay,
Yes.
it's an arbitrator decision.
It's a very strong principle that is confirmed by our case law, that the tribunal, the arbitration tribunal, the arbitrators have jurisdiction to decide on their own jurisdiction. And the courts of law, generally speaking, comply with this.
Is there a general practice about how arbitrators are chosen? If there has to be an odd number, is it generally one side picks one side picks another, and together they pick the chair? How is that normally done in Brazil?
Well, it must be an odd number under the law. Well, it depends if it is a case of a sole arbitrator or a case of a panel. If it's a case of a panel, generally speaking, each of the parties nominate one arbitrator and they decide on the third one. Of course, with some variations depending on the applicable rules, but generally that's what it happens.
So when you have a commercial dispute, is it generally 3 arbitrators or 1 arbitrator?
That's a very difficult question, you know. I always felt a bit unusual about solely arbitrators, because arbitration is something that, generally speaking, there's no appeal. So if for any reason you do not think that the decision is correct, and it may happen, there's nothing you can do. And sometimes when you have a panel, you can have different perspectives, different ideas, and any kind of control about the final result. But this, I can say that I had very good experience with sole arbitrators there as well. Maybe I was lucky, I don't know. But
Maybe
it
you're just
depends
good.
also, yeah, it depends also on the size of the dispute, because depending on the size of the case, maybe 3 arbitrators may be too expensive.
So one of the things you told me when we were talking about the presentation of evidence is that the parties generally present the documents together. Now, I wasn't sure exactly what you meant by that. So could you explain that?
It may be simultaneously, it may be in different moments. It depends on the case.
Okay. So do you have to generally get a document into an arbitrator through a witness at the hearing, or if both parties agree that a document's relevant, you don't have to show it to a witness to get it before the arbitrator?
Well, generally speaking, witnesses do not deal with the production of documents. So it falls on the parties that to produce documents, to present to the tribunal, to give the opposing party opportunity to comment on them, and to produce their own evidence.
Do decisions from the arbitrators have to be in writing?
Yes.
Okay. And do arbitrators have to hold merits hearings? Do you have to have a hearing before you can issue a decision?
No, you don't. Usually we have a hearing. It's a common practice, I would say. It may be a hearing for the production of oral evidence, or even expert evidence, or the experts can be inquired about their reports. But sometimes, not very usual, but it happens. I had cases like this before. You are dealing only with, let's say, with legal discussions. The facts are not a matter of controversy, and you can still have a hearing so that the parties may present their case, their positions, and make it possible for the tribunal to make their inquiries. So, but in any event, there is no imposition. It's not mandatory to have a hearing, but in most of the cases we have a hearing.
So if you don't have a hearing, is that the decision of the parties, or can the arbitrators decide that?
It depends on the proceedings you agreed on the case. It's very difficult to say it generally, okay?
Okay.
But in most of the cases, the arbitrators inquire the parties if they want to have a hearing, most of the cases. But the arbitrator himself or itself, or if it's a tribunal, is able to decide upon the hearing, even if the parties say that it's not necessary. Because he's going to decide based on the evidence and the arguments submitted by the parties. And it may be the case that he wants clarification.
Sure. Is there a rule like in some common law jurisdiction regarding paying another side's costs and attorney's fees if you lose the arbitration?
There's no rule about this in the law specifically. What the law says is that the arbitrator is going to decide about who is going to support the costs, but does not say how it's going to be. It depends on what, in most of the cases, depends on what is agreed by the parties. in the arbitration agreement or even the terms of reference. Generally speaking, the terms of reference or the arbitration agreement determines how the costs are going to be held by the parties. In most of the cases, who loses pays more.
And does that include the other parties' attorney's fees, costs, and things like that sometimes?
It depends on what has been agreed on the applicable rules. Again, there is no mandatory rule about this in the law.
So if there's no agreement,
for instance,
yeah, go ahead.
For instance, I saw a case in which the terms of reference or the arbitration agreement clearly stated that the parties were allowed to recover the costs incurred during the arbitration, the payments of the arbitration fees, the payments of exit, but not the fees paid to their own lawyers that they should support it. Sometimes the agreement says that even these fees, if reasonable lawyers' fees, can be recovered. Depends on what is agreed.
So, and maybe you don't know this because it doesn't happen enough, but if there is no agreement among the parties regarding fees and costs, what do the arbitrators generally do?
The arbitrator have to decide. And the problem is that there is no clear indication in the law for this. What he may try to do is to apply by analogy the regulations for the proceedings in courts of law that says that the cost has to be proportionally divided by the parts, take into consideration what their success in the case. But really, it's very, very uncommon to have it not previously agreed, because if the arbitration agreement does not have a provision for this, when the terms of reference are prepared, usually the arbitrators impose to the parties to decide on it, because he wants guidance on how he's going to solve this problem. It's very unusual. Well, let's say in commercial cases that it's not have been previously agreed.
So we talked a lot about arbitration, and you mentioned that one of the tribunals you mentioned was an arbitration and mediation tribunal. I know that in prior discussions with others in certain jurisdictions, mediation was not as accepted as arbitration. Is mediation part of the process in Brazil? Is it growing? What's the status of mediations?
Yeah, what I can certainly say is that mediation is not so strong practice as arbitration, but it's growing. In the last years, there are lots of indications that it is growing, but it's not a very strong practice. Maybe it is going to be in future.
Is there a reason you can think of that it hasn't been a strong practice in Brazil?
Well, the law has the instruments for this. It's perfectly possible, allowed, enforceable once you mediate and agree on something. I think it much more is a matter of culture, possibly, as I see it. But I think that, as I mentioned, it's improving, and there are very, very clear data in relation to this. But in any event, during the arbitration, the parties are free to stop at any moment to mediate. And under the law, the tribunal, the arbitrators are always expected to invite the parties to reach an amicable solution if it's possible at all.
How about in court? Do Brazilian courts try to get parties to mediate, or is that just not part of the history?
It is, but it's not always applied. For instance, our Code of Civil Procedure that regulates the proceedings at court states that when you file a claim, the judge is expected to have a preliminary hearing to see if he can mediate the parties. But it does not happen in all the cases. In most of the cases, this hearing just does not happen, and the courts understand that's okay, because the judge is free to decide that it's not going to happen at the moment because there is no time to do this, and it's very unlikely that at that stage of the proceedings the parties are able to reach an agreement.
Understood.
So there are instruments, but they are not fully used, I think.
So when you said it's not a cultural tradition for mediation, do you think that's because in the court of law the judges don't do it very often? Is that why it hasn't become part of the culture, or is there something else that impacts the cultural difference that didn't accept mediation?
Well, in part because the judges do not do this very often. I believe they do not have the time to do this. In a place like São Paulo, the amount of the disputes that a judge at the court has to deal every year is really tremendous, you know. And he simply does not have the time to dedicate to this, okay? Reasonably. There's no time. But I think that it's something related to our adversary culture as well. I believe that's not much the case. But as I said, this is changing because when you have really rude disputes, sometimes complex arbitration shows to be very costly. And if there is any possibility of efficient mediating it at all, it certainly is desirable
Sure.
by the parties. Yeah.
Well, I appreciate the time for our discussion. Is there anything that we haven't talked about that you think people should know about alternate dispute resolution in Brazil?
No, I think that we covered all the main aspects. What I can say that, as I mentioned to you, Brazil has a very strong practice in this alternative dispute resolution methods, especially arbitration. And you can have an arbitration in Brazil as you can have in other places around the world. Yes.
Well, Marcus, thank you so much for your time. It's been a pleasure talking to you and learning a little bit about being a trial lawyer in Brazil.
Okay, thank you very much.
Thank you
for this invitation, and it has been a very, very interesting experience as well. Thank you very much.
Thank you.